Vermin is what they had been called. Parasites is what they had been called. Destructive is what they had been called. But these, the vermin that once infested colonial America, the parasites that preyed on the misfortune of their neighbors, until finally they were officially banished from Virginia, those dreaded, despised, inevitably outcast masters of confusion were lawyers. And now you know the rest of the story.
Okay. Do you have any other witnesses?
Judge, I briefly intend to call myself, and I do have a couple questions for Dr. O'Connor. I want to be mindful of the court's time. Would the court prefer that I testify next or that we call Dr. O'Connor?
It's up to you. I think it's probably most efficient to call yourself next.
Thank you, Judge. I would call myself. Would you like me to swear in?
Yes, let's go ahead and do that, so that Dr. O'Connor can cross-examine you at the conclusion of your testimony. Do you solemnly swear or affirm that the testimony you'll give the court will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Dr. O'Connor, did you have a question?
Yes, ma'am. I was just going to object to his testimony first and ask that I testify first.
Well, it's still his case in chief, and so I'm going to allow him to take witnesses in the order that he chooses.
Yes, ma'am.
And then
Yes,
once
ma'am.
it closes, you can call yourself as a witness first. If he doesn't.
Yes, ma'am.
Okay, Mr.
Yes, Your Honor.
Thompson, you may proceed. And you may testify in the narrative, and Dr. O'Connor, you just object if and when you see fit.
Yes, ma'am. Thank you.
I'm going to be going back and forth with the Mr. Doctor, but
That's fine.
all right, Mr. Thompson, you may proceed. Okay.
Judge, my name is Marshall Thompson. I'm an attorney licensed to practice in the state of Texas for 13 years. Also appearing with me is my associate attorney, Megan St. Germain, also with my office. We have been hired by Ms. Ho to represent her in this case, and we have represented her continually since 2016. Well, with a brief break during the lack of a modification, and then since 2018, continually since that time. Ms. Ho has agreed to pay me, and in exchange, I have agreed to represent her at a reduced hourly rate of $262.50 per hour. We have agreed that my associate will represent her at $150 an hour, and that my paralegals will all represent or assist her at the rate of $120.75 per hour. I can represent to the court that all of those levels are significantly below the market rates. My normal hourly rate at this time is $450 an hour. However, because this case has been so expensive, I've agreed to maintain these reduced rates in order to make it somewhat feasible for Ms. Ho. I have prepared, at this time, Ms. Ho has paid my firm and still to this day owes my office just under $20,000, $19,000 and some change. To proceed with this case and to finalize this case, I have created a fee summary of what additionally needs to be done, how much I believe it's going to cost at those reduced rates, and how much it's going to take to get this trial done. If I may, at this time, Judge, I'd like to share what's been marked for identification purposes as Respondents Exhibit 10.
You may.
Respondents Exhibit 10 is a anticipated legal fee and expense worksheet. As you can see, we have broken out by task how much time we think it's going to cost for the further temporary orders, how much it's going to cost to proceed on discovery, how much it's going to cost to compel the discovery, as the court's not hearing it today, but we're going to have that issue. The Daubert challenges, because Dr. O'Connor has designated both Dr. Farrell and himself as expert witnesses in this matter, which will require Daubert hearings. Depositions of new fact witnesses. We have done quite a few depositions, but additional fact witnesses are now part of the case. Fees related to the custody evaluation, review, all of that, and then the prep for and attending the trial. As I spoke with the court this morning, it was not clear if we were proceeding to jury trial or if we would proceed to bench trial. However, I have reviewed the amount of work that's going to have to be done, and I believe this estimate is essentially appropriate for a very long, contentious bench trial. Finally, we do have a line item on here for paying Dr. Sherry's expert witness fees. It's my understanding from speaking with her that $20,000 is essentially what it's going to cost her to update the report and to be present at a 5-day trial. All in all, Judge, the anticipated fees to get from today until a final order for Liam is $100,240.25. I recognize that's a jaw-dropping number. I'm not happy to be here asking for that kind of money. I don't like it, but that's what it's going to take. This is the most complicated case I have ever been on, the most voluminous record, the most witnesses, exhibits. This is an 80-page custody evaluation. And I think under the circumstances, getting these people to resolution when frankly, I think the testimony is going to show that Dr. O'Connor has spent hundreds upon hundreds upon hundreds of thousands of dollars prosecuting this case. This is the best investment of money that these parties can make at this point, is to get this thing finalized based on Dr. Sherry's report. And so I would ask the court to award this amount in interim attorney's fees and expert fees. And with that, I will pass myself.
Thank you, Mr. Thompson. And Dr. O'Connor, do you have any questions for Mr. Thompson?
I do, actually, and I do object to the proposal as a whole. It appears that they want to continue a suit, even though I've non-suited, and yet they want me to pay for them to pursue a suit based upon what they think is Dr. Sherry's valid recommendation. So I object to that, Your Honor. But I do have questions for Mr. Thompson, if I may. I guess in the time that we have, I'll move. So, Mr. Thompson, you had mentioned that you are charging Ms. Ho $250 per hour. Is that correct, at a reduced rate?
$262.50 per hour.
Okay. And your paralegal is charging $120.75?
Yep.
Is that correct?
Yes, sir.
Okay. And you mentioned administrative assistant. And what's the charge of the administrative assistant?
No, I mentioned an associate attorney billing at the rate of $150 per hour.
Okay. Now, you and I, you have a contract with Ms. Ho, is that correct?
That is correct.
Okay. And in no way or shape or form has Dr. O'Connor been involved in that contract, is that correct?
That is not my contention. Okay.
And in terms of the Texas Civil Practice, I believe in Remedies Code, Chapter 3801, since there's been no contract, really Dr. O'Connor has no obligation to be involved in payment of your fees. Is that correct?
We are seeking interim attorney's fees under Section 105.001 of the Texas Family Code.
Okay. And Section 105.101 speaks directly to safety and welfare of the child, correct?
105.001. That's right. Any temporary orders necessary to preserve the safety and welfare of the child, including payment of reasonable attorney's fees.
And that has to be specific, the safety and welfare of the child, not ambiguous. I mean, it has to be specific to the safety and welfare of the child, correct?
The fees have to be related to protecting the child's safety and welfare, yes.
Actually, I object, non-responsive. So bear with me, Your Honor, I just lost my screen. Okay. Thank you for your patience. But I mean, it's very specific. There has to be specific. There can't be a loose connection, Mr. Thompson. It has to be very specific. The fees, are they divided out to safety and welfare of the child? If you're going under this statute, are they divided out according to welfare, safety and welfare of the child? What hours specifically you, your assistant attorney, and your paralegal are going to spend for direct safety and welfare of the child? Have you segregated out those fees?
All we are doing is asking the court to incorporate the safety and welfare recommendations that Dr. Sherry recommended. And so every single dollar on that spreadsheet is related to implementing those recommendations, which are related to safety and welfare, yes.
But as you know, I think we've already established Dr. Sherry is not present. The report doesn't have a business record affidavit. And from what I'm understanding, the report hasn't been admitted from evidence. So that, therefore, it couldn't be used as a basis for safety and welfare of the child. And correct?
Your question was, what of those fees relate to safety and welfare? And my answer is all of them.
I'm sorry?
My answer is every single dollar on that sheet is related to safety and welfare of the child.
Mr. Thompson, we're losing some of your words. It's a little bit hard to hear you at times. I don't know if you can get closer to your microphone or uncover it. Thank you.
Any better?
Okay.
Yes. Thank you.
So as was mentioned earlier, there's going to be a Daubert challenge. And until the Daubert challenge is done, we don't know whether or not Dr. Sherry's report or even Dr. Sherry will be admitted as a witness, correct?
I suppose. I believe the burden's on you to challenge a witness.
Yeah, thank you for answering the question. So really, until that time, there is no segregation of fees according to the safety and welfare of the child.
I disagree.
Okay. And in going back, safety of the welfare of the child, it must be specifically met to meet the criteria 105001, correct?
I'm sorry, what is your question?
The criteria to meet Texas Family Code 105.001 relating to attorney's fees awarded for the safety and welfare of the child, that has to be specifically met. It cannot be a loose connection, correct?
Yeah, I think Henry Rogers makes clear that you can't just talk about vague generalized ideas. There needs to be an actual concern to be addressed, and the money needs to be an actual concern.
Yeah, and Henry Rogers actually talks about that safety and welfare has to be present tense, not in the past. And it was even stated that because mom was able to maintain some savings, that they were not able to rule to award attorney fees in that instant, correct?
No, you misread that case outrageously.
Well,
what that case says,
I disagree.
I'm sorry, you asked me my opinion. I'll tell you it. That case.
I wasn't asking your opinion. I object, non-responsive. I was asking you yes or no if it was correct or not. And you said, no, it's not correct. Thank you. Thank you. But there is other case law, for example, like, and I apologize, Your Honor, Henry TMF, basically. And in that case also says, you know, we don't just use attorney's fees to even the playing field. You know, that case also specifies that it is about safety and welfare of the child. In addition, there are other cases, you know, such as Saxon, Doggett, and another case as well, that disparity of finances is not justification for awarding attorney's fees. And what you're asking is because, and what she's testified, your client has testified to, the question is, your client has testified that she cannot afford the court hearing, that Dr. O'Connor, and client has testified, Dr. O'Connor is super rich. So in order to level the playing field, you want attorney's fees, correct?
I'm going to object to that compound question, Judge. That was
okay. I'll rephrase the question. Your client has testified that she cannot afford to pay you, correct?
That's true.
Okay. And what you're testifying to is Dr. O'Connor makes a lot of money and can afford to pay you, correct?
No, I have not testified to that.
Okay. Okay. Because your client cannot afford to pay you, you want to level the playing field.
No, that's not true. Because my client cannot afford to protect Liam's rights, legal fees are necessary to protect his rights. That's what we're here asking for.
Again, going back to safety and welfare of the child, Mr. Thompson, that is not even in evidence. So we can't even use that, correct? Has the report been admitted to evidence?
No, I never offered the report.
The report has never been admitted to evidence, correct?
Correct. I never offered the report.
Thank you. Thank you. So really, the request for attorney's fees can't be even related to safety and welfare of the child per the report. You stated, I've never admitted the report, correct?
The court has heard an entire day of testimony about the substantial concerns, and that is what
non-responsive, sir. Non-responsive, object, non-responsive. I would like you just to answer the question, please. I'll rephrase it. I apologize. Since the report is not admitted as evidence, its basis cannot be used related to safety and welfare, correct?
I don't understand what you mean by its basis. The basis of that report.
The report can't be used as a basis the report cannot be used as a basis to determine the safety and welfare of the child or to make recommendations.
Well, now I don't know about making recommendations. I can say that I'm not relying on the report today here as the basis.
Thank you, Mr. Thompson. You've answered the question. Thank you. But yet you're not relying on the report, but yet you're asking for attorney fees based on the report. You've said it earlier, correct?
No.
I'll take that as non-responsive. I'll move on.
I said no.
Okay, thank you. So now you're asking under 105.001, correct?
That's right.
But again, you're asking for fees to go to a final trial, correct?
Correct.
Okay. And that's usually ruled by 106002, interim attorney fees.
You're citing now the section that relates to fees after trial. I'm not asking for that because we haven't had a trial yet. I'm asking for interim fees.
Okay. There's not, I've non-suited. I've canceled non-suited my pleadings. I've abandoned or withdrawn my jury trial demand, but you want to pursue jury trial, correct?
No, I'd prefer to try it to a bench trial. But you, of course, have the right to request again a jury trial if you so choose.
Okay, so you and your client want to pursue further litigation, correct?
My client wants to protect her child, correct?
Non-rejection, non-responsive. Again, you're okay. Yeah. You've testified earlier in a contradictory fashion that your request for attorney fees is related to the report, which is not admitted to evidence. You base safety and welfare related to the report that's not admitted to evidence. So really, there's no basis for safety and welfare of the child.
Is that a question?
It's a cross-examination question. Yes or no? There's no basis for safety and welfare of the child without the report.
I disagree.
Okay. So you give an estimation of these fees. We haven't, correct?
That I gave an estimate of fees? Yes, that's correct.
Yes. And for many years, you've offered Ms. Ho a discount of fees, correct?
Since I've represented her, that's correct.
And that contract was between you and Ms. Ho, correct?
Yeah.
Correct. Yes?
Yes.
Thank you. So actually, through all the years and hours that you've billed Ms. Ho, you've actually lost money compared to the clients that pay you fully. So for example, if I could clarify my question, you're charging her $250, but I believe your regular rate is $450, correct?
Charging her $262.50.
Yes, but and your regular rate is $450?
As I said here today, that's true.
Okay, thank you. So approximately every hour you bill her, you're losing about $200 an hour, correct?
Yes, depends on how you look at it.
Okay. So, well, again, compared to your regular clients that pay you fully, you're actually losing money per hour.
I don't understand.
Okay. All right. So I see it, correct me if I'm wrong, that every hour you bill Ms. Ho, $262.50, you lose out, golly, what, at least over you lose out at least over $150 an hour that you're not making.
Well, I don't think I can correct how you see it.
I'm sorry?
You said the way I see it, correct me if I'm wrong. I don't think I can correct how you see things, if that's your opinion.
But, okay, the sole point is that you're not making your regular rate when you bill Ms. Ho per hour.
Yeah, that's absolutely true.
So you're losing money for every hour you bill her.
I lose money on every pro bono case I take. I lose money on every reduced fee case I take. I lose money every time I volunteer at the legal clinic. That's just how it works.
Mm-hmm. Mm-hmm. And so Dr. O'Connor is the deep pocket.
I don't understand that either.
Well, and so by continuing litigation unnecessarily, you have an opportunity to make up that lost income.
I'm going to object. That's an improper hypothetical.
Sustain.
Okay. I mean, Dr. O'Connor has non-suited, correct?
Yeah, I think we have covered that you filed a non-suit. That's true.
Thank you. And Dr. O'Connor has stated he wishes not to pursue his pleadings, correct?
I believe you stated that, yes.
And when Dr. O'Connor non-suited back on April 26th, and you disagreed with Dr. O'Connor's non-suit, correct?
Right, because this child is in harm's way. And until we resolve that, until we address it, litigation will have to continue. No one wants to be here. Ms. Ho does not want to be here, but she has.
Mr. Thompson, you've answered the question, yes or no. Thank you. But you have no evidence that the child is in harm's way.
You heard evidence today.
Based on one person's report, who bases it on the report of Dr. Sherry, which is not admitted as evidence. Correct?
I'm sorry, I don't understand the question.
That's okay. That's okay. So really, it will benefit you and your firm, Thompson, Salinas, and Londergren, to pursue litigation to make up for the lost wages.
That's absolutely untrue. I'm here asking for these fees because my client needs relief. That is the only reason.
And that's why you have a contract with your client and you're pursuing litigation so you can keep spending your client's money.
No, I disagree. I'm pursuing litigation because my client needs help and the child needs help.
So really, when we talk about safety and welfare, and we talk about TFC 105001, I haven't, there's no clear connection that's being made. You're saying that all these fees are related to that, but you've not segregated these fees. And when we talk about 106002, you know, interim fees for final trial, when there's no final trial, but that's what you're continuing to pursue so we can get interim fees. And we talk about chapter 38001, the only one that has a contract with you is Ms. Ho, and Dr. O'Connor doesn't have a contract with you. So the question is, what clear and convincing evidence has been laid down today showing that there's a safety and welfare issue with the child?
That's an issue for the court to determine. And I have, it's 4:30 now, and we've gone well over the requested hour to 4 hours of time that you will ask the court to allot for this case. And so we need to go ahead and wrap up.
Yes,
I'll give you, 5 minutes more if you need to get something else on the record. Otherwise, I'm going to go ahead and make some rulings so we can get you all on your way.
Okay. If I could admit Exhibit 13, Your Honor, real briefly, let me get
That's petitioners 13. And Mr. Thompson, any objection?
I'll take a look, Judge, but while I'm thinking about it, I never offered respondents 10. At this time, I would like to offer respondents 10 as a summary of the fees that I expect in this case.
Okay. Any objection to either petitioners 13 or respondents 10?
Respondents 10. I do have an objection to respondents Exhibit 10, Your Honor.
Okay. What's your What's your objection?
The objection is that it doesn't relate specifically to safety and welfare of the child, and the premise used for that is evidence that's not admitted, and there's no fees that are segregated, and it doesn't directly apply to TFC code 105.001, nor does it apply to 106.002, nor is there any relation to 38001. I don't mean to be so long-winded, but that's my objection.
Okay.
If I may.
Well, I'm gonna object it, but only for this narrow purpose and only as a
Yes.
summary of Mr. Thompson's testimony and not anything other than that. It's just an outline of what he told court.
Thank you, Judge. And as far as petitioner's exhibit 13, I can't say that I understand the relevance of this exhibit, and I don't believe it actually could be authenticated, but in the interest of time, I'm not going to object. It can come in, whatever.
Well, the only thing, if I could share the screen, Your Honor, real quickly, is that, let's see,
You may.
Is going down in terms of reasonable fees. This is actually taken from the U.S. Bureau of Labor Statistics, Occupational Employment and Wage Statistics, and going down to the average fees of attorneys going over, they make $67.69 with an average income of $140,000. That's the pertinent part of this exhibit. I just wanted to state that in previous testimony, Mr.
You don't have to
Thompson
get
has
into
said that
any
he,
details because there's no objection. So petitioner's 13 is admitted.
thank you, ma'am.